Today we're going to talk about the top 4 ways to avoid probate. My name is Gregory Singleton. I'm an estate planning and probate attorney living in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm serving the Twin Cities and Greater Minnesota alike. If you like what you see in today's video, please feel free to like and subscribe below. It sure helps support the channel. With no further ado, the top 4 ways to avoid probate. So the theme of today's video is that probate sucks. We're not going to go into all the reasons why probate sucks, but in general, just believe me that it does. It's a long process that can take 6 to 24 months, during which time your assets can be frozen, and it can be very expensive. There are personal representative fees, there are attorney fees, there are court costs, there are notice fees. That's not as bad in Minnesota as it is in some states like California, New York, or Florida, or some other jurisdictions which have mandatory minimums for personal representatives and attorneys. But in Minnesota, it still can be pretty egregious. So let's figure out the top 4 ways of avoiding probate, at least in part, and then we'll let you decide what you want to do. We're going to be covering a lot of topics very briefly in today's video. I will be going into some of these topics in much more depth in future videos. So if you feel a little bit cheated and don't quite understand the topic after today's video, I apologize, but we'll get there. So don't you worry. So the first number 1 way to avoid probate is using a transfer on death deed or a payment on death account. Now, this is a Minnesota law authorizes what's called a transfer on death deed or a payment on death account. A transfer on death deed, what it does is you sign, let's say you have a house or a car, and I have a house or a car. I would sign a transfer on death deed so that when I die, Bill gets my house. Payment on death account is essentially the same. If I have a bank account, I would just say on my death, Bill gets my bank account. What happens at that point is when I die, Bill takes a certified death certificate plus the appropriate affidavit to the registrar and files it, and the property immediately transfers over to Bill, or if it's a vehicle, to the DMV, or if it's joint account, to the proper financial institution, and they will have their own affidavit that you would need to, requirements that you will need to fill out. What it does is, since the property immediately transfers from me to Bill, it doesn't go through probate. A lot of people do this to decrease the assets in their accounts or in their estate, so that instead of having a full formal probate, they can use a probate alternative such as transfer by affidavit, or maybe just informal probate, which is a little bit easier, a little bit less expensive, and takes a little bit less time. The next number 2 way of avoiding probate is using joint accounts or joint ownership. And this is very simply where you and another individual have equal ownership of the account or the property. So if you have a house, you could go into joint ownership with your spouse, for instance, or with a friend or a brother or sister. If you have a bank account, you can go into joint ownership with your spouse, for example. When you die, the other person still owns the entirety of the house or the bank account. You don't each own half of it. You both own the entire thing. So all the person needs to do is take a certified death certificate to the appropriate authority. If it's a property, to go to the registrar. If it's a bank account, go to the financial institution. There will be an affidavit that you have to fill out, most likely. File it or record it. And then the other person will be removed from the dead person will be removed from the ownership of the property. Since there has been no break in ownership, the property doesn't go into probate. So it's kind of slick. A couple things to note, though, or at least one thing to note. There is a question of taxes. If you have a joint account with someone and you die and your estate is possibly taxed, there may need to be basically an accounting of exactly how much money each of you contributed to the bank account. However, to find out whether that money is subject to the tax. However, the federal estate tax exemption is $11.7 million starting in 2021. And in Minnesota, it's $3 million. So as long as your estate in total is less than $11.7 million, you're not going to be taxed on the federal level. And if your estate is less than $3 million, you're not going to be taxed on the state level for Minnesota. Some other states have estate taxes too. I don't know what their levels are. A lot of states don't have an estate tax. So if you're in one of those states, then you just have to think about the federal tax level. The third way to avoid probate is by using gifts, and these are just giving gifts while you're alive. We have an annual gift tax exclusion of $15,000. So basically, you can give away $15,000 a year to as many people as you want. So $15,000 to Bob, $15,000 to Susan, $15,000 to Bill. And you don't have to report that to the IRS, so there's no transfer tax. Obviously, these funds will avoid probate because you don't own them at the point that you die. You've already given them away. Now, there's a couple ways to do this. First, you can just do a direct gift. Let's say you have adult children. You could say, I'm going to give you each $15,000 a year for the next 5 years because I want you to have the money and I want you to see you use it while I'm alive, and so I can kind of enjoy seeing what you do with it. Maybe watch you buy a house or buy a car or put it into your retirement. But let's say instead of giving to adult children, you are giving to grandchildren who are, let's say, 10 years old. Well, you probably don't want to give $15,000 directly to a 10-year-old because you don't know what they're going to do with it. There is, however, a way to do it that puts the money into a trust. Now, I'm not going to go into all the details, but it's called a crummy trust based on I believe it's a case from the 1960s. It might have been the 1940s. I think it's the 1960s of Crummy v. IRS or Crummy versus someone. And it's a tax court case where they established and authorized what the crummy trust does. Again, I'm not going to go into the details of how to establish a crummy trust or how a crummy trust works. I'll just say it's real slick. So if you do want to give a large amount of money to someone but want to make sure that there are some trust protections in there, talk to your attorney about a crummy trust. The final gift giving mechanism that I want to talk about is a supplemental needs trust. If you have someone that's on Medicaid, which in Minnesota is called medical assistance because of a disability, and you want to give them a gift, there might be a problem. Because to qualify for medical assistance, they have to have a minimum number of assets, which I believe is $3,000 in Minnesota, and then also a minimum amount of income every month. If you give them $15,000, they are going to have more than $3,000 minimum asset amount, and they will no longer qualify for those benefits. That can be a real problem. You don't want to screw with someone's benefits if they're on disability. What you can do is create what's called a supplemental needs trust. And again, there will be another video on supplemental needs trust down the road, just not today, but essentially you can put money into a trust. The individual with the disability can use it for their health, education, maintenance, and support. And you're able to give that $15,000 or more if you want to pay the transfer tax or less without losing access to their medical assistance. So it's a real neat way. I highly recommend looking into them if you want to give a gift to someone that has a disability and is on medical assistance. Now, I do want to warn people about one gift that a lot of people try to do, which is giving their house to their children. Now, there's ups and downs of it. A lot of times people, when they get close to wanting to go on Medicaid, they need to spend down their assets and they don't want Medicaid to claw things back. So they will say, give their house to their child and say, dear child, I'm giving you my house as long as you let me live in it for the next 5 or so years until I go on into medical assistance. At that point, the house is yours outright. There's a couple things to watch out for. First of all, your child may not want you to live in the house. You could transfer the house to them, and down the road they could say, maybe at the behest of a spouse that you don't like, say, let's kick the mom out or kick the dad out and sell the property or turn it into a rental for property. You have no guarantees. It could be also no guarantees if your child has, say, a gambling problem or has major creditors or has a divorce with their spouse. That becomes an asset subject to the creditors or the divorce. Remember, this is probably a secondary house, and if it is, it's not going to be homesteaded, so you're not going to have those homestead protections. The third thing you want to watch out for is the tax implications, and there's two. First of all, you're giving a major asset to your child worth a couple $100,000 or more. That's going to be subject to a transfer tax. You have a $15,000 gift tax exclusion. Presumably the house is going to be worth more than $15,000. So, and if it is, there's going to be a transfer tax on the transfer from one individual to the other. Second of all, you're going to lose basis. What I mean by basis is, let's say, for example, you purchased the house originally for $10,000. 10 years down the road, the house is worth $50,000. If you sell the house at 10 years down the road, you're going to make income of $40,000. It's the difference between your purchase price, which is your basis, and the sale price. However, if you die and transfer the house at death, the basis steps up. And so if you die when it's worth $50,000 and your child immediately wants to sell, and you give it to your child and the child immediately wants to sell the property, they don't have to pay the difference between $10,000 and $50,000. The basis steps up to $50,000 and they don't have to pay any income tax on it. If you gift them the house, you lose this step up in basis. So just something to be aware. And there's my dog barking in the background, but I'm sure she's got a good reason for it. The final, number 4 way to avoid probate, and this is the big one. I'm not going to talk about it much because I do so in a number of other videos, but it's the Revocable Living Trust. This is the granddaddy of avoiding probate. To explain what a Revocable Living Trust is, I like to use a metaphor. You've probably heard it before if you've watched any of my videos, but essentially it's a metaphor of a box. While you're alive, you put all your stuff in this theoretical box. And you can, while you're alive, you can put stuff in the box, you can take stuff out of the box, you can move stuff around in the box. The box is yours. You own the box, and the box is what owns your stuff. When you die, the box closes, and the box lives on. The trust keeps living on after you've died. Because your stuff is in the box, and the box keeps living after you've died, and probate only affects things that are in your personal estate that you have ownership with, all the stuff in the box doesn't go into probate. It's kind of slick, huh? And then the box works as kind of a will on steroids and gives all your stuff out to everyone, just like you would for a will. It's a neat process. Again, I'm not going to go into all the details about a revocable living trust, but just so you know, the option is out there. Watch some of my other videos on the difference between a revocable living trust and a will. Maybe get you and talk to your attorney about it, and if you think it might be right for you. So that's the top 4 ways to avoid probate in Minnesota. If you liked today's video, please feel free to like and subscribe below. It sure helps support the channel. If you have any questions, go ahead and ask them in the chat. I only practice in Minnesota, so I can only apply Minnesota law. But a lot of the theories and laws are similar from one jurisdiction to the next, so I may be able to answer it in some capacity. Otherwise, until next time, this is Gregory Singleton from Signature Law.